Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to talk about sectional title scheme rules. You all know that every scheme must have rules. Well, we'll qualify that statement in a second. But in terms of subsection 35(1)(a), a scheme shall be controlled and managed subject to the provisions of the Act by means of rules. There is one exception to this principle, but it's very seldom used in practice. Under Regulation 30 made under the Act, a scheme can assign its management to an overarching homeowners association or property owners association, and in this case, the prescribed rules can be substantially done away with. But there are still some issues that have to be dealt with by rules. For example, the appointment of trustees. You can't, under the Act, run a scheme unless there are trustees holding office in terms of the rules. Each scheme can, of course, create its own scheme rules to deal with its own particular circumstances, so you must never assume that the prescribed management and conduct rules apply unqualified, unchanged to every scheme. You need to check that out. Subsection 35(2) sets out the purpose and types of rules. It says that the rules should provide for the control, management, administration, use, and enjoyment of the sections and the common property, and shall comprise management and conduct rules. These, of course, can be made and amended by unanimous and special resolutions, respectively. Now, in terms of subsection 35(5), rules must be reasonable and apply equally to all sections put to the same purpose. Any management rule, conduct rule must be reasonable and shall apply equally to the owners of units put substantially to the same purpose. Who must obey the rules? Well, subsection 35(4) answers this question by saying that the rules bind owners and occupiers of sections, and from the time the body corporate is established, they bind the body corporate also. A rule cannot bind a visitor, for example. It can't require a person visiting a section wear shoes whenever he passes across the common property, for example. But this type of provision, or something more sensible, can be partially achieved by having a rule that requires owners or occupiers to ensure that their visitors wear shoes when they are on the common property. And it might also, if it were a more serious thing than wearing shoes on the common property, provide a penalty of some sort. But the penalty would be payable by the owner or occupier, one of the persons bound by the body corporate. Let's look at disabled persons. They're not exempt from scheme rules. So, for example, in regard to the hanging out of washed clothes to dry, a disabled person may ask to erect a particular type of clothesline, which the rules provide cannot be done without the consent of the trustees. The rule applies to the disabled person, but at the same time the trustees must be reasonable and take the person's disability into account when considering the request for consent, and similar principles apply when dealing with an application to keep a dog if it happens to be a guide dog, for example. Lastly, let's look at who must enforce the rules. The enforcement of the rules is not listed as one of the body corporate's functions under Section 37, but under Section 38J, the body corporate has the power to do all things necessary for the enforcement of the rules. Sometimes it's difficult to determine who should take action in enforcing the rules. There's no doubt that in most instances an application to court to enforce the rules can be made by a body corporate. It can also be made by an owner or any occupier of a section. Yes, I believe even a tenant has the right to have others abide by the rules that bind him also. However, this doesn't assist us in determining who should make an application to court and bear the initial legal costs. Generally speaking, a body corporate should not become involved in disputes that involve only occupiers and owners, and where the dispute has no relationship to the common property. The body corporate is obliged to control and administer what happens in sections, but in a very limited way. All the bits in the Act that deal with controlling actions within sections are situations where those actions would negatively affect owners generally. Therefore, the body corporate shouldn't become involved in any dispute which doesn't concern or relate to the common property directly or affect the interests of owners generally. For example, if an owner is having difficulty sleeping because the occupier above bangs the floor, then the person affected should make the necessary application to the court. The body corporate should not become involved. On the other hand, as another example, if an owner or occupier has done something that negatively affects the appearance of the whole building from the street, then it is proper for the body corporate to make that application. I hope that this has been of assistance and we can discuss any matter arising in the discussion forum.